appearance rate. However, I'll prefer extension of time. Costs will follow the event, inshallah, because that's the law regarding costs since civil procedure rules are elements of justice. So, hope workshop 1 was a bit light, but workshop 2 lighter, not so? So, as I made it a point last time that when it comes to criminal proceedings, everything is the same. We are just emphasizing a few points here and there. However, you should be able to appreciate the fact that when it comes to criminal, a few things that change are basically evidence which we need to put into consideration so that we are able to appreciate criminal. As I told you that criminal proceedings is basically a matter of evidence. You should be able to appreciate that these two workshops that you are having, the difference is evidence. In workshop 1, emphasis was basically on documentary, expert opinion, evidence. So basically, when you look at your tasks, you are dealing with the tendering in of expert opinion, documentary, evidence, the medical reports, because that is an opinion of an expert, but it was in a documentary form. And the general rule is under section 59 that evidence will be given by the person who saw, who had, or who. So that's what we call the best evidence rule. So for that effect, workshop 1 was testing that type of evidence. So workshop 2 came in and they made a twist from expert opinion. They added on another type of evidence, which they want you to sit down and appreciate how it is dealt with. Okay? Before we drill down in the workshop, ask yourself, who is the main witness in workshop 2? Who has defiled? How old is that girl? Under what category is that girl? Now we have a legal meaning. Okay? Child of tender years. So they want you to appreciate evidence regarding tender years. So do you know how to conduct a FOIA daya? That's what they are testing in that workshop. And besides that, who saw that person? Okay? Who saw that person defiling? Who saw? The person who saw is the minor, not so? So that means they are also testing the principle known as single identifying witness. Okay? Because in social-related offenses, the victim is the only witness. The victim is the only witness. So as a result of that, you should be able to appreciate that in all sexual-related offenses, you only have one witness, and that witness is the one that is referred to as a single identifying witness. So for that matter, when you are reading your workshop on the Christian criminal, emphasis should be on evidence. Are we going to repeat? You already know the offense that is there, not so? The violation of evidence is okay, but they are testing. I told you until you leave the purpose. the presumption is you read the evidence act cover to cover. You know each and everything in that act. That's what they presume. So they keep on changing the type of evidence and they see whether you appreciate how to deal with that type of evidence. So workshop 1 had just something small, expert opinion. That was the best. Okay. And after these guys understanding that it seems you have appreciated expert opinion, they decided now to add another category of other 2 categories of evidence. Okay, that is single identifying witness and then evidence of a minor. And then we have hearsay evidence in workshop 2. Okay, because the complainant is the mother. Not so. Was she there? So she has hearsay. So what is the law regarding hearsay evidence? Okay, is it admissible or it is not? If it is admissible, okay, what is its weight? Okay, what is its weight? So what does that mean? You're going to reappreciate the law on collaboration. What type of evidence requires collaboration? Okay, so they just put something to keep your minds thinking about the appropriate evidence to abuse. Okay, so you ask yourself, okay, when it comes to this type of evidence that you have in workshop 2, if it is in the question, it's an exam, okay, can you really sustain that type of evidence? What do you know about it? Okay, so the best with criminal that you're not going to go back to your evaluate evidence what an abuse, but what we have now, okay, that category of evidence, can you really deal with it? If they, because me, my second question was to distinguish between a minor and a child of 10 years. Then after they told me you are the sitting magistrate, the prosecution's witness number 1 is him, is aged 7, proceed. I had to conduct a voyeur diary. And then after, because it was one question, but it was a follow-up question. Then after they told me, what's the distinction between a voyeur diary and a trial within a trial? So another workshop they'll give you, they may give you when the witness is a person of unsound mind. All of those are things you should be able to appreciate. So now, let's get to the workshop. Let's get to the workshop. Learning outcome number 1, it says, by the end of the workshop, each of the students should have furthered the ability to peruse a police file and identify possible offenses disclosed and their ingredients. Do we need to go through that? Yes? Do we need to go through that? Okay. We need to identify the possible offenses disclosed by the workshop. Yes? Do we need to go through it? Which statement do we read when identifying offenses? The complainant. Okay? When you read the complainant statement, it's just straightforward. That's it. Which offense is disclosed by the complainant statement in workshop 2? Okay? It says that I am of the above address. I did state that I am the biological mother of Chirabo Jane. I know she is 8 years old. I produced her when I was 10 years in 2014. The biological father is Kasivante Budu. Being that I was young and unable, I was not given the chance of staying with my daughter. All the time, she has been staying with her father and relatives. Has been staying with her father and relatives. It is only recent that she started coming to stay at mine, but during holidays. She has never been through with me to tell me her problems she is facing. It is today, on that date, that I have heard of this ordeal of sexual harassment done on her by the biological father. Okay? I want you to underline that she's aged 18 years. Yes, underline she's aged 18 years. Okay? She's underlined that she's aged 8 years. Let's underline that she's 8 years. Okay? Then underline the last one. Okay? That I have heard of the ordeal of sexual harassment done on her by her biological father. Underline the word biological father. Underline the word biological father. Okay? Okay. Then let's go to the complainant statement as well of Kakoza Yeremia, where he states that the above particulars are mine. I do wish to state that okay, go on. Okay, he says that the above particulars are mine. I do wish to state that today, the 3rd of February 2022, at around 16 hours. Underline 16 hours. What time is that? 4 p.m. What does that indicate? There are sufficient light. What would have answered? Okay, we proceed. Okay, while at home, a daughter of my neighbor by the name of Chilabo, a pupil at Kabalagala Primary School, came and told me that she wants to talk to me in private. I told her to go ahead to do so. She showed me 2 condoms and said that her father uses those condoms on her at night. I got scandaled, even asked her whether she had ever told anybody about that problem. She told me that she told Mama Vivian about it, that her father plays sex with her at night. I told her to stay around as I confirmed from Mama Vivian. When I asked Mama Vivian whether she had ever received any information from Chirabo about her father playing sex with her, she told me that the girl told her, but she thought that maybe the girl was deceiving. From there, I opted to come and report the matter to police for proper investigations. That's what I can state as of now. Statement recorded from me, read back and confirmed. Which offense is being disclosed? It is abbreviated. Which factors are abbreviating this offense? Age, And then this guy, relationship. Okay, relationship. Okay, and then we need to confirm is the father positive or negative. Okay, so now we still need to appreciate the first issue. What offenses are disclosed by the facts? We have settled that. So we've seen two aggregating factors. So that was followed. Okay. So now, do we need to do I want you guys to try it. Oh, I can do it again. Yes? You read the case of Uganda versus Dr. Kano Kisa Besigye. It is applicable that rape case. Remember that? Okay. Dr. Kano Kisa Besigye, where it was alleged that he defiled. Okay. Remember, it was alleged that during the early 2000s, he was having sexual intercourse with a certain girl who was a maid. Okay. So when he stood up for the 2016 general presidential elections, that matter came up and court resolved it. Okay. So that case has the scale of evidence in sexual related offenses. Okay, it's 2016. Okay. 16. Remember that part which had problems? Scale of evidence in sexual related offenses. Okay, so we had a lot of issues with that matter. By the people from Kawape, congratulations. Thank you. Huh? However, at least. Okay, but now, but in regards to this, the workshop you guys have covered. Okay, I want you to go and read that for me. Get an opportunity of reading it. Okay, in High Court we have what we call exceptional circumstances. There are three. You choose one. Okay, so which exceptional circumstance they have failed to prove grave illness, but the DPP gave them a certificate of no objection. That's why he sent an order that we withdraw all responses to bail application. Zona neziva record. Neziva with a certificate of no. That's what they say the DPP has not objected to. That's why I've been seeing it on social media that the DPP has sent an order to withdraw all correspondences from the DPP's office in regards to response to bail, but they couldn't write it automatically. But if you're a lawyer, you can understand that they have used exceptional circumstances under section 15, subsection 3 of the TIA. That's what we call a certificate of no objection. But they are still, they're not yet, I think, Mamas of Bat, I think. Okay, but they have not yet reached Kampala. Reason, they had to pay the cash bail, eh? But still it's not the news. Yes? But the loss is still applicable. Those guys are also fighting this, what we are doing right now. Okay, so let's go on, okay? Let's go on, okay? So now, we identified, so now, the emphasis basically why I have come to deal with evidence, okay? To deal with evidence. So the evidence we have today, if you are dealing with evidence, you have two types of evidence, okay? I don't know how you guys are going to write it, but it summarizes the entire act. We have two types of evidence, okay? Just try that. Have you ever done what we call a family tree? So this is called the evidence tree. Okay. At the top, we have evidence. Okay, the what? Evidence. So under evidence, we have two types of evidence. Okay. How many weeks? How many weeks for us? Huh? How many weeks for us? So here we have evidence. Okay. So we say that we have types of evidence. We have direct, okay, and then indirect. Okay. I will get. So ask yourself, under direct evidence, what we have. Okay. So whenever you give a workshop, ask yourself, am I dealing with direct or indirect? Okay. And if it is direct, which type of evidence basically? So if you realize that these people are dealing with direct evidence, okay? So direct evidence is either oral or written. So ask yourself, oh, what have you covered? What should one dealt with what this time? Both were there, but emphasis was so much on written. Okay? So under written, what do we have? We have primary and okay. You saw in your workshop, didn't you have secondary evidence? Okay, you had it. So that means when you are dealing with the workshop, evidence cuts across. So now, for purposes of today, we are dealing with which type of evidence? Oral. So ask yourself, okay, under oral evidence, what types of evidence do we have? Okay, we have what we call inculpatory, okay, and exculpatory. What? Okay, this one means inculpatory and exculpatory means incriminating yourself. Okay, so what type of evidence can incriminate you? That okay, me, we work with juries. Those are what we call admissions and confessions. Okay, you get it. You yourself, you are incriminating your. That's what it's called inculpatory evidence. It is direct and it's oral. Okay, it is direct. No one is going to come and admit on your behalf. No, no one is going to come and confess on your. That's why it's called direct oral inculpatory evidence. So you ask yourself, have you come across any statement where someone is somehow, somewhere incriminating himself? Okay. Yes, we are today. Then exculpatory, when someone is giving evidence that exonerating him or her soul. Okay. Those are times where you have what we call factual witnesses. Okay. People who give they are here, they are testifying, but they are saying the contrary. Okay, they are not incriminating themselves, but they are incriminating some other person. Okay, I will get. Okay, so now for today we are under oral. Okay, we said under oral we have admissions, confessions, and then you have this exculpatory. Okay, so now exculpatory, some other person is testifying, incriminating someone. So now, when you look at our workshop, do we have people who are giving evidence but incriminating someone else? Okay, so under that, That's when we are going to, under this, we deal with what we call minors. Okay. We have adverse age. We have dumb witnesses. We have hostile witnesses, and then lastly, what's after hostile? We have the factory witnesses. Okay. So now, but what happens when you are here? They always give you what we call role play questions. Okay. If they want to deal with the hostile and the factory, they will give you a role play question. They tell that assume you are in court and you have paraded your first witness. However, upon examining her in chief, she's saying this and this. So when she has turned into a hostile or a factual witness. So they want you to make a prayer there and there. Okay, chances are high it may be in your workshop too. Okay. Then, if not, here we have advanced age and then advanced age for infants. Okay, yes, okay. So, as per your workshop, we are dealing with minors, infants, and then people of advanced age. Okay, so that's why if you bring evidence of an person of advanced age, it is questionable. Consider. Okay, if you bring a child of 10 years, that evidence is. So what does this imply? This evidence at times requires corroboration. Okay, so now let us come to our workshop. Okay, so you guys are intending to do evaluation of evidence. Okay, but I want you to look at the evidence on record. Okay, yes. Hey, you can't decide. Hey, sorry. Now it comes to indirect. Okay, which evidence can be yes, sir. When you look at the constitutional guidelines, they say above 6 years. Okay, so here indirect, we have circumstantial, and then what else? Hearsay. Okay, so under hearsay, you have to look at what we call exceptions of hearsay. That's why we are going to have a dying declaration. What else? What's the second exception? Well, the general is hearsay evidence is inadmissible. Okay, but we have circumstances where that evidence is going to be admissible. So the first exception is a dying declaration when you are on the deathbed. Okay, but you see, if you follow this, summarize the entire evidence. But reading that act, you didn't even call your grandfather. I read it from here. Okay. No, collaboration works here and here. Okay, because courts are hesitant. Okay, in convicting persons on half-baked evidence. So under such circumstances, where it is hearsay evidence, it should be corroborated. Where it is circumstantial evidence, it should be corroborated. Where it is evidence of a single identifying witness, it should also be corroborated. So when you get your facts like this, okay, first ask yourself, who are you? Okay, which type of evidence is before you? the evidence you have, can court proceed and convict on that type of evidence or not? Okay? So that's where we are. Okay? What's the second exception? Hearsay evidence. I'm also forgetting. Yes? When I remember, I'll reiterate the same. Okay? No. Okay? This goes under this. Okay? So now, okay? Circumstantial, this is just evidence that draws an inference to the occurrence of the event. So when you get the workshop, ask yourself, what type of evidence I have? Okay? 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 We also have this recent one of but the current one is Uganda versus Uwera. This is the cheapest current. Okay, so now when you look at this, okay, when we get back to our facts, the question we need to ask ourselves is the evidence on our file sufficient or insufficient? That's the question. Okay, the evidence on our file, is it sufficient or insufficient? Aisha, is the evidence sufficient? Are you sure? Who is your main witness? Yes, who is the main witness? Hilal. How old is she? 8. Are you sure that she understands the relevance of telling the truth? Yes? So, when you look at this workshop is almost the same. Okay? Let me just actually what I think. Let's just read these tasks and we attach our facts below. Because the rest of the things are the same. So even the tasks are the same. But you're going to find a legend who has no one. You work with the backwards. Already work on Mulina or Solo Copo, you know, down while you know to supply number. Name again and doing now. Okay, so task 1, identify the offenses, if any, disclosed by the facts and evaluate evidence in support. Not so. Then 2, assume investigation are complete, draft the documents as a to. Now, I want this. Assume the role of a judge. Remember what I told you? That at LDC you are 3 in 1. You are a judge, you are prosecution and defense. So at all times, be ready to be any of the 3. Whether in orals, whether in an exam, whether in the workshop, be ready. Katigobo Jango Mani, you came here to study to become a lawyer. We also want judges from here. Okay? Don't be surprised, you know, you write a judgment. Let's go on. Okay? They are saying that assume the role of a judge. Okay? Assume the role of a judge. The matter is coming before you for hearing today. The victim, Chirabo Jane, is the witness. By way of demonstration, what preliminary steps would you take before taking her evidence? So, remember I told you, this is direct evidence, but direct evidence of a child of tender. So the first thing, which law defines a child of tender years? In the first place, that was my first question in Boros. I did what? I can't do what? And that's nothing COVID. Yeah. Question they gave me follow-up questions. Oyingira vote ng'oli mukyamufu ne wabaawo ekikuba banoonya engeri gye bakutereeza nga kale abadde amanyi naye empewo emuyiseemu just. So they find means of dealing with you mpola. They bring you back on board. So when I was very confident. I have everything. My musajja okugamba give me the case. Nasirika nasikirina. Give mazima. Nangamba okay, give me any other authority. Nensirika. Nengamba okay. Nentandika the 1995 cancel. Amazima oyagala kuwa asana katejimanyi okuyiriza. Neka tukwagwize. So they gave me 3 follow-up questions in the same question, okay? But all relating on the same theme. So first things first, you can't be judged who is going to conduct a voyage diet when you first and foremost, you don't know under what circumstances a voyage diet is conducted. So the first thing is, you understand a trial within a trial and what are the different examples of a trial within a trial. Council here, what's a trial within a trial? That's a trial. Don't make a break. We are fast. That's if the mind knows bring a proof, we should understand that we have 2 different things. We have a trial within a trial and a voyage diet. Zinga natula mu room gwenti. Olaba ngoyingira mention.
Rashid.
Yes.
There are some people in the waiting room. Kindly admit them.
They have been admitted, Council.
Okay.
Okay. I was in that room down there. Omusajja yandecha Kasada. The guy was my friend. Yajja aseka. Natuka yeyanona. Rashid. How is Kasam Tembuli? It's okay. Let's go. Kanogenda vayo. That question. They first asked me the law defining a child of tender. Yes. Name Kuba. Nadia Nambuza Council. What is a trial within a trial? This person was trying to direct me that a voyage diet is an example of a trial within a trial. Nainga obongo bujja. Ngendo picking okudda went. Nasigaze dakiikezi. So I had to speak all the nonsense around by that time to survive. Okay? But on them. So let's get on board. What is a voyage diet? Okay? Okay, so a voyage diet, a trial within a trial. These are circumstances under which the trial stays the main trial, stays a main trial to conduct a mini trial to ascertain particular set of facts, to conduct a mini trial where a judge stays the main trial, to conduct a mini trial, to ascertain particular set of facts. So then ask yourself, what are the different examples of a trial within a trial? Okay, so the first one is a voyage voya diet. So let's ask ourselves, what is a voya diet? What is a voya diet? Okay.
Rashid, I think I didn't get the definition of what is a trial within a trial properly.
We say that a trial within a trial, these are circumstances where a judge stays the main trial to conduct a mini trial to ascertain the truthfulness of particular set of facts. Okay, so we've been giving examples of trials within. So we said the first one is a voya diet. So the question is, what is a voya diet? Okay, voya diet, VODIRE. Okay, VODIRE, voya, then diet. Okay, so a voya diet, this is when a judicial officer conducts a trial within a trial to ascertain whether a child of 10 years understands the nature of proceedings before him or her, and the rationale behind telling the truth. The trial okay, so now the question is, what law defines a child of 10 years? Council, give us the authority that defines
129 for AFN.
Okay, section 129. Okay, penal code. Okay, so now, should we read the provision or we shall read it? We shall read it. So now, after this, okay, ask yourself, how do we conduct a voya diet? Because this task requires you to conduct a voya diet, okay? To conduct a voya diet. So what question you ask the judicial officer should you press to the camera? So let's assume this is Chirabo. Okay. Okay. So what questions do you think they would ask Chirabo to ascertain whether she knows? Because I want to ask Chirabo. Chirabo is here. Were you defiled?
No.
Yeah. You answer. What's your Chirabo gift?
I'm 8 years old.
Do you go to school? Do you go to school?
Yes.
I'm 8 years old.
8 years old. Yes. Not to go to airport.
Okay. That's what you should start with. Chosen items. Okay, but what they want, one, when you are dealing with children of tender years, the first thing is to create a free and lovely environment. You ask those guys who work in court, Baba next week, Baba okay? The judge goes out, they sit somewhere, okay? So what do? They chase out the rest, okay? So what it will be demonstrative, okay? It is done in chambers, not in open court. So when they take, because you're not supposed to write anything on this task, okay? Basically, because it is a role play question. You have to come, the group that is presenting, you get a judge, you get the girl, and you start asking. Simple as that. Okay? Okay, no, you presume. You just presume. You say we presume we are in chambers. Okay, then you start. How are you? You go to school. You love Sunday school. Which song do you sing in Sunday school? Why? You want to make this child so friendly to you. Then after you start asking, you go to school. Yes. Who is your favorite teacher? Why? You want to pick the memory to see whether this child can recall a number of events. When did you last go to school? She will tell automatically. Then you ask her, did you go to Sunday school? Yes. Did you go to Sunday school last Sunday? Which pastor came? Okay. Do you understand Jesus? Yes. Okay. What doesn't Jesus like? Doesn't like liars, doesn't like thieves, doesn't like people who kill, because that's why they teach in Sunday school, obvious. Okay, then what happens if you like Jesus? You'll go to fire, they will burn you into ash, because that's what they teach. So once you see that, you understand that, okay, this girl understands the essence of an oath. Okay, why? When you come to court, you're going to testify, you're going to give sworn evidence. So that means when this baby takes an oath, she understands that alayide mu linnya lyaki lya Katonda talina kukola ki kulimba. That's the rationale. Once you pick that, everything becomes. That's what is required in prayer.
We make a difference where I change the year 129 section 4.
There is a case. I'm going to get a case for you. Another case that defines it is there. Okay? Yes, sir. Yes. Then you make a ruling. Okay? Yes, you make a ruling that having conducted a trial within a trial, I have come to the conclusion that the child understands the nature of the, okay, whatever, because it's a trial within a trial. You make your ruling that I have ascertained that the witness fully understands the nature of proceedings before, okay, before him or her, and understands the rationale behind telling, okay? Yes.
What are the checks and balances against some issue? The group is narrow the judge. Is there not in the kid and then it comes? What checks are there?
Because after that, the child is going to be put in open court. Mr. Judge. Okay, that's why you first create that free environment. Okay, then if not a void die, which other trial within a trial you can conduct? The second trial within a trial you can conduct is to ascertain yes, okay. Another is ascertain the truthfulness of a confession. Okay. Once a person says that that's not my confession, we just go within a trial within a trial to ascertain how that confession was recorded. So it is also a trial within a trial. Okay. Then the third one, to ascertain the truthfulness of an admission. That's the third trial within a trial. Just it's an initiative of court. You don't apply. Yeah, you take up. All right. Okay. Then the fourth one, to ascertain the truthfulness of a charge and caution statement. You can one proceedings, but where that the confession is young, kati judge ayina okukakasa kituufu baamalamu kuba bukubi recording like that. Okay, to ascertain the truthfulness of a charge and caution statement. Okay, the third one was to ascertain the truthfulness of an admission. Okay, a void die. Then the second one, a confession. The third one, admission. Fourth one, charge and caution. Okay, all of those are examples of a trial within a trial. Then lastly, to ascertain the mental capacity of the witness. Remember Stella Nance, when she addressed herself in court, okay, of the witness. Okay.
To ascertain what?
To ascertain the mental capacity, okay, of yes, okay. Okay. So then, so remember what happened to Stella Nance? When she unaddressed, the proceedings were stayed. Okay, how can you undress in public like that? The words she was uttering. When she was taken to Butabika, what she did, she started the classes of political science. So she was teaching, so she was teaching them their fundamental rights. So she wanted the entire section to learn political science and they strike. Proceedings is very on camera, not in open court, because they realize she's a danger. Okay, so where such things happen, the main trial is put at stake and then they first ascertain. So that's what we call a trial within a trial. So there is a main matter that is proceeding. So it is first stayed, then court ascertains all of those. Okay, so what does that imply? When you look at the workshop, it had a voyeur die. So they expect you to have read all categories of a trial within a trial. Okay. So, assume you state the above matter has been set down for hearing today. It has come to your knowledge that the doctor who examined the victim relocated to US. Was that thing in workshop 1? So what is that? Tendering in of expert opinion evidence. So this is a medical report. When you read section 59, evidence is supposed to be given by the person who had who saw or who. So what does this mean? Okay. According to the best evidence rule, the best person to tender in this medical report is the doctor who made. So now ask yourself, does that rule have exceptions? So what are the exceptions? And provided for under which law? Get the Evidence Act. Okay. Let's get our Evidence Act. Yes. So, where is the exception in the Evidence Act? Who came across it? Yes. Okay. So, statements made by persons who cannot be called as witnesses. So the exception relies under section 30. Okay. So that's where the exception is. Where the person who made a statement can't be found, section 30 cures the problem. Simple as that. So all you need is to make a prayer, you qualify it. Okay. But when you are writing, for example, one section 30 of Kanokolachi, first write the best evidence rule to show that these are the exceptions. Okay. Don't just come and write anyhow. Okay. Then what steps would you take to ensure this particular topic is that one is dealt with? Carry out the role play, how it is done. Assume that you are a practicing advocate with instructions to represent above accused on state brief in the forthcoming criminal session. Outline the practical steps you will take to ensure that you professionally represent your clients. Okay. Answer. Formalization of instructions. You go and you interview your client from prison. You write that letter. So you see that even the next workshop will deal with of premium. It will be the same. But I have to choose one other type of evidence, which is not that. Okay. Okay, there is a case that has been sent on the platform. Defines a child of tender. Yes, so make use of it. That the question has been sent. Okay, so any questions? Any questions? Any questions? This is how criminal is simple, but I assure you, you have to prepare a single words room. That's the challenge. On the face of it, it looks simple, but the day you start writing it, becomes the most difficult. Why? Because of all abanga in Yahweh, your criminal game, I will read at a later stage, but the later stage becomes the problem. Okay, so what is necessary here? Regardless, when you look at this, make sure all sexual related offenses are covered, and each offense you have a case. Okay, all the principles you've highlighted of evidence, you've read them. Make sure you read the case of a single identifying witness. Okay, which look at the case of Abdallah Nable bin Wendo. Okay, make sure you've read it. Okay, Abdallah Nable. Okay, is it R versus Abdallah Nable? Okay, Republic was it okay, then even you got even numbers. Uganda versus Uganda is also a good one. Okay, I think it's on reading this. Okay, then if you had murder, read that is an threat on murder, read an threat on manslaughter, read an threat on infanticide. When it is rape, it is defilement. Read the case on defilement, read the case on aggravated defilement, read the case on rape, because you are dealing with sexual related offenses. That is wiki. Sexual related offenses again. Your emphasis again up yeah, chimu. Okay, and after putting all your emphasis on only that one thing, okay, what will happen? Okay, ogenda tukamu exam bakugambe tulese infanticide kali nagiwulirako bajogerako ekuwunzike walayo kirize. Okay, okirize okay, so don't risk. Make sure you've taken all the coverage. We are, you see these steps they're giving you. That is always all the role play. That's a question for orals. Role play. So that you're going to play that role. Group B. Okay, role play. And since that you're the judge, okay. Okay. So if I come that this, do that. Okay. Oba gama nti oli judge, why judge immediately? Tula mukatebe ko comfortable, start giving a ruling for the judge. Bakugandi oli judge oyimiridde. Wala be judge abera mu court na yimiridde. So whatever you see now, it's a role play. Understand how the role is played, you will make it to heaven after here. Okay, you see the colleague who died the morning? Yes, that guy was in 2021, 2022. So he had a supplementary, started last year. And a few weeks back, he was appointed by General Muhoozi as his country coordinator for the youth project, host project, and he was earning some good money. Unfortunately, he had diabetes. Okay, so he fell sick and he lost glucose. Just within a day, everything. So enjoy when you still have the opportunity. Okay, don't get afraid. Always pray to God that you get a good ending. For us in our year, a colleague was crossing the road like this with the gun to bring it here. Bam, with God. In Zambia, imagine I was coming from Makinde, so we bypassed the guard, not knowing that is my colleague here. Bam, to make day. Already in here was submitting my. Hello, man, what make the wali never did not cut out this. So everything happens for a reason. You guys are the chosen ones, that's why you're here, and I believe God will choose you to live this place. Have hope, believe in Him. Okay, so assalamu alaikum wa rahmatullahi wa barakatuh. Tomorrow, let's meet for cancel for the week. Okay, inform all those guys who are canceled for the week to kindly come. Okay, yes. Okay, so thank you. You're welcome.